Hi everyone, Keith Carlson here from Carlson and Jai Kumar. Wanted to update you on some of the cases we were watching in the last part of September. First up is Maxwell versus Atria Management. In this case, a resident of a senior living facility was admitted and her child, who had the power of attorney, signed an arbitration agreement which would bind her and her family members on a future lawsuit. She had an accidental death in the facility, and the lawsuit was brought into Superior Court. Atria then turned and sought a motion to compel. It was initially denied because a different child had a healthcare power of attorney, and the court believed that the arbitration agreement was a healthcare decision, thus the second child would have had to sign, not the first. The Court of Appeal was looking at that, and fundamentally the question is an arbitration agreement in a healthcare setting a healthcare decision or not? The Court of Appeal reversed the denial of the motion to compel arbitration, sending it back to the lower court, wanting them to analyze it under a recent case of Herod v. County Oak Partners. And the Court of Appeal thinks that actually doing so might make things even a little bit more confusing, because there the Herod decision said agreeing to arbitrate was not a healthcare decision. The Herod case said that it's not a healthcare decision even if it's done in a skilled nursing facility. Despite both these cases, what I think we can take away is there's still ambiguity, as when, like in the Maxwell case, one person holds a healthcare power of attorney and another holds a durable power of attorney, and we're going to see what the lower court does and the new facts that they've been asked to find. Next up, Kim v. Uber Technologies is a case where a Uber driver had hit a person but had already turned the Uber app off, basically was off the clock when they hit the pedestrian, and Uber moved for summary judgment, and that was granted. The pedestrian brought it to the Court of Appeal saying he had just been working for Uber, probably going to work for Uber later. Court of Appeal affirmed, and that was thrown out on summary judgment. Next up is a case out of the Ninth Circuit, actually in Hawaii, but Hyer versus Honolulu. It deals with expert reports, and in the case, the trial court denied admission of expert reports because the facts that the expert had relied on were not admitted facts in the case. The Ninth Circuit said they don't have to be, and had that been brought in, there would have been a genuine issue of material fact. Thus, the plaintiff could have avoided the summary judgment that was granted, and that error was prejudicial. So that one was reversed, sent back down. Another Ninth Circuit case is called Stein v. Kaiser Foundation. And in this one, the Ninth Circuit reversed a district court's dismissal of a False Claims Act. The question was jurisdictional on the first to file rule. There's been a split in the Ninth Circuit, and so this was taken up en banc. And the Ninth Circuit ruled that the Act's first to file rule is not jurisdictional unless Congress says it is in the statute, which is not in the FCA. And they were basing their reasoning on some Supreme Court rulings recently to not overly use jurisdictional in what the court has called a profligate way. And they said that in Sebelius versus Auburn Regional Medical Center in 2013, and then again in MOAC, Mall Holdings versus Transform Holdco just last year. Next up, Miller versus CDCR, California's prison authority. Miller worked as a correction officer and got hurt. She eventually couldn't work anymore and ended up on unpaid leave. She finally sued under various FEHA claims alleging disability discrimination, failure to accommodate, interact, etc. CDCR was granted summary judgment. The plaintiff could not overcome summary judgment on her disability discrimination claim by pointing to evidence that might show another separate FEHA violation. Basically, you got to win on the claim that you brought under FEHA. In Campbell versus Sunshine Behavioral Health, Campbell sued her former employer for wage and hour issues on her own behalf and for a class. The parties entered into a stipulation to mediate. Then Sunshine, some 6 months later, found she had signed an arbitration agreement. They went to mediation. They were then demanding arbitration. The court found that there was waiver, and the Court of Appeal affirmed that, so no arbitration for them. And they said you don't have to show prejudice to the plaintiff, you just have to show that acts were taken in furtherance of litigation, and the matter was waived. Last up is Civil Beat Law Center versus Maile. This is another Ninth Circuit case under Hawaiian law. Hawaii mandated all medical and health records filed in any court action be filed without further order from the judge, and the Ninth Circuit deemed that unconstitutionally overbroad. The state cannot mandate sealing without a case-specific analysis by the court, given the First Amendment's granting of the public a right to court proceedings. So that's what was going on late in September, and we hope you enjoy this update. And if you have any further questions, you just let us know. Thank you. Bye-bye.